Ladies and gentlemen, a very warm welcome. Thank you for taking the time to be with us today. We would like to welcome you to the 6th In-House Council Forum program. My name is Samir Shah and I'm an M&A partner in Khaitan's corporate M&A group. Once again, a very warm welcome to all of our audience in India and around the world. This In-House Council Forum is now in its second year, building on the tremendous success of the first edition as well as the firm's other virtual M&A programs in recent years. As the name itself suggests, it has been designed specifically for in-house counsel teams in India and abroad, and it offers bespoke professional training and education in topics of interest to in-house counsel, including legal and management topics. In the last year, the forum was by invitation only and was therefore private in that sense. This year, in addition to invitations which we continue to issue, we decided to open the forum to public and not keep it solely by invitation. Nonetheless, we do aggressively manage webinar registrations to ensure that only in-house counsel team members are present at live sessions so as to preserve the purpose of the forum. We hope through this process of providing continuous legal training and executive education on matters of interest, we are able to hold our participants' interest and their attention. To introduce our topic for today, key issues in ESG due diligence. As businesses worldwide have increasingly recognized the importance of environmental, social, and governance factors, or ESG, the need for robust diligence in any acquisition has become more and more crucial. ESG diligence goes beyond traditional financial assessments and, in fact, integrates a more holistic evaluation of risks and opportunities that affect not only the deal but also the long term sustainability of the business. Today, our panel will address the complex legal and regulatory landscape concerning ESG due diligence, both in India as well as globally. We will also examine the challenges posed by a lack of standardized ESG metrics and the various strategies we have seen our clients employ to navigate evolving local and international compliance requirements. Through this session, we aim to equip you with practical insights into tackling the key challenges and leveraging opportunities that a diligence presents in modern day corporate transactions. Therefore, once again, thank you very much for joining us, what promises to be a very valuable and insightful discussion. As we move to the agenda for today's webinar, as always, the format will be a panel discussion with our expert panel members, including a Q&A session with audience questions towards the end. We hope that the session will be interactive and we invite you to ask questions during the webinar as and when issues arise. Please continue to use the chat box in the webinar portal. We have already received several audience questions and will be answering those as well. If we cannot cover all the questions during the webinar, we will of course respond offline by email after the webinar. And summary notes of the webinar will also be circulated to all of you after the webinar as a matter of course. I would like to introduce our panelists today. For everybody who registered for this webinar, you would have received an email providing credentials of the experts on our panel. So I will not spend much time repeating or summarizing their credentials. Suffice to say that they both have a great deal of expertise and excellent credentials to be able to speak on this topic. We have my partner, Mr. Prasanjit Chakravarti, who is an M&A and corporate partner with Khaitan and Company. And we have with us my colleague, Ms. Pavi Jain. She is also a counsel with our M&A and corporate team. So without further ado, we would now like to switch to the panel discussion. And perhaps I will start with Pavi. And Pavi, if I can invite you to talk a little bit about what is the broad legal framework for conducting ESG due diligence in India?
Hi everyone. Thank you for the question, Samir, and delighted to be joining this discussion today. ESG is definitely moving forward than ever before. Regulators, of course, have realized, everyone's realized its worth beyond the hype. One of the key contours of India's ESG regulation today is the BRSR and the BRSR core. BRSR is the Business Responsibility and Sustainability Reporting. This requires the top 1,000 public listed companies by market capitalization to make ESG disclosures in their annual report. Around 145 indicators have been specified in the BRSR, of which most are essential, meaning mandatory indicators, and the remaining are voluntary indicators. At a congruence, BRSR also congrues with international reporting standards such as the GRI, ISSP, TCFD, etc. And the BRSR core, which was very recently released, pairs itself with the ESG reporting directives of advanced ESG nations. To specify what the BRSR core mandates is there are certain 9 key ESG reporting parameters such as GHG emissions, intensity ratios, job creation in smaller towns, etc. Now, these core parameters, top 150 public listed companies from this year will also have to procure a reasonable assurance for these core parameters. What it means is that you have to go to a third party auditor to procure an audit of these reportings against these 9 parameters. Interestingly, where we pair with other advanced ESG nations is that the top 250 public listed companies now also have to make a reporting of their value chain disclosures. Now, supply chain ESG parameter is definitely the most talked about aspect in the EU market, the US markets, and also in India because of the BRSR core. It prescribes that the top 75% of your value chain entities, your downstream as well as upstream entities, you'll have to make ESG disclosures for those. Couple of our clients are definitely facing issues here because essentially, how do you go to a tier 3 city, ask your supplier in a tier 3 city to make disclosures about job creations which they are doing in tier 4 cities? So, because of the top 75% parameter, this has started to become an important aspect for each value chain partner who belongs to the value chain of a listed entity to ensure that they are identifying these ESG parameters, they are keeping the data ready so that tomorrow at the time of disclosure, the listed entity, when interacting with them, feels that there is adequate preparedness. Apart from these two parameters and regulations, we also have the nuanced carbon credit trading scheme, which is for the hard to abate sectors. Type of obligated entities, for instance, aluminium, iron ore, steel, fertilizers, etc. You will have a cap and trade system. Your GHG emissions will have a particular target. Your emissions cannot cross that target. If they cross that target, then you'll have to purchase carbon credit certificates from entities who have produced lesser GHG emissions. Then you also have the recently introduced green credit rules, which was introduced last year. We're still waiting for the implementation framework to be introduced for different activities under the green credit rules. As of today, the implementation framework only for plantation related activities have been introduced. What it provides is a voluntary carbon credit mechanism, but in an organized manner. So, 7, 8 activities such as plantation, green farming, sustainable agriculture, water harvesting, etc., fall under the parameters of green credit. You get your project registered with the administrator under the green credit authorities. They will, in the plantation framework, for instance, which has only been released, they will then plant those many plants for you. In the next 3 years, they will see where the plantation has gone, and based on the assessment of the administrator, then green credits will be issued to you. What is a comforting factor is that the voluntary carbon credit market can function in parallel with the green credit as well as the carbon credit market. And your voluntary carbon credit market can continue as is, so to speak. You can keep your trading your carbon credits on, let's say, a Singapore exchange or anywhere in the world. That demand and supply will really not be affected because of this. There are also certain nuances in terms of greenwashing to dos, the Advertising Standard Council of India, the Consumer Protection Authority releasing guidelines against greenwashing, and we will also be discussing these towards our next set of questions.
Great. I think that's an excellent starting point. And maybe Prasanjit, I come to you. And in your role as a transactional lawyer, when you're advising a client on due diligence or for that matter, transactional agreements, how do you deal with the lack of standardized ESG metrics? How do you budget for that?
Thanks, Amir, and firstly, very warm welcome to everyone. And my apologies, I've just recovered from a terrible bout of viral, so may sound a bit hoarse. So please bear with me. I think, firstly, look, as far as ESG is concerned, we know that there is no one single law which talks about ESG. It law is scattered all over the place in the form of Companies Act, CSR. Pavi alluded to some of the listed company norms like BRSR, some global standards like GRI. Now, all that means is, when you have to evaluate our target company and do diligence, it's very there is no uniform standard. That's the first part. Having said that, what you should do as an investor is to engage with lawyers and ESG advisors to firstly prepare a checklist which factors in and tailors in the relevant kind of action items which a target company should be mindful of and be doing. We obviously have to factor in the fact which sector the target company is operating, which part of India, the local regulations, etc. Is it listed? Is it unlisted company? What's the paid up capital or market cap of that company? All of that should be factored in. Is it a labor intensive kind of a company? All of that should be factored in when you kind of prepare that checklist. So once you do that, that's the first exercise, is to kind of prepare this customized tailor standard checklist and then share it with the target. And then on that basis, test the waters as to whether the target company, how does it fare. Has it fared poorly, has it fared well? And many a times what we get in diligence is just tip of the iceberg. We have to really dig deeper beyond paper diligence, go to site visits and see if actually the company is really operating in a ESG compliant manner. Depending on the outcome, obviously, when we draft the transaction documents, there could be certain action items which we want to fix as a condition precedent. Let's say the target company is not housing its effluents properly, or we want to have a system in place before we invest, that it should house its effluents properly and not recklessly discharging its effluents. Of course, there could be other action items which could impact the valuation itself. For example, there could be a potential contamination issue. Now, and if that's a threat looming large, I would also suggest a earnout or some kind of a deferment, so that while this issue plays itself out, I am not overpaying for the company and overvaluing it. So the second kind of protection in transaction documents, there should be customized representations and warranties underpinned by indemnities, which should be there. Many times people make mistake of having standard environmental warranties and assuming that's good enough. Uh, with the advent of ESG and the way it's developing, you must have experts look at those warranties and customize them, have specific indemnities which fall outside the purview of general warranties, and have specific measures to tackle that. So, in summary, yes, there is no standard metric. We have to create that. Bit of effort goes into it. Having created that, you should then tell the target, educate them, and really assess the target basis that, and build in these contractual protections to mitigate against any liability.
Very interesting. I think that's a very good perspective. And maybe it's an evolving area of law. It's new not just to us but to the rest of the world. Pavi, any lessons, let's say from Europe, from their regulations that Indian companies can learn from? Is there any relevance to those regulations to Indian companies at all?
Sure, sure. So I think EU regulations are definitely not geographically or temporarily far. They're already really here as far as Indian companies are also concerned. Let me give a brief overview of what those EU regulations are and how they're applicable to the Indian businesses today. I will only be talking about those regulations which are applicable to Indian businesses today. So, for instance, let's start with the EU CBAM, which is the EU Carbon Border Adjustment Mechanism. This is already in its reporting phase, and from 2026, one will also have to start paying if their carbon emissions for certain hard to abate sectors are beyond the permitted GHG emission norms in the EU. So, to give you an example, hard to abate sectors such as iron ore, steel, cement, fertilizers, each of these have a permitted GHG emission permissible in the EU. Any importer from the EU who is, let's say, importing steel from India will have to ensure that the carbon emissions in the cradle to manufacture of this particular element does not exceed the permissible norm in the EU. The moment it exceeds that permissible norm, you will have to purchase the EU CBAMs, and therefore, really, your export duty today, what sits at a 2%, would exponentially increase to a 20%. So companies such as JSW Steel, Tata Steel, Vedanta, they've already started implementing measures to either produce green steel or to ensure that they are imposing carbon pricing in their internal value chains, etc. So that's the EU CBAM. An important aspect here is that even products like plastic packaging after 2027 will be engulfed in the EU CBAM. So one will also have to have a forward looking aspect here in terms of their ESG diligences in India. The next and most talked about is the EU CSDDD and the EU CSRD. This is all part of the EU Green Deal. What it imposes is EU CSRD is very similar to the BRSR that we have here, but just with a more wider implementation, because not only does it apply to the listed companies there, but also large EU companies with certain turnover and employee thresholds. What the EUCS-DDD, which is the due diligence directive, does is that if you have more than 1,000 employees in the EU, or if your turnover in the EU is more than euro 450 million, then you will have to ensure that there are certain environmental and human rights due diligence aspects which are built into your policy directives. You will then need to assess the impact of these, mitigate if there are any such violations, and also eliminate them. The important factor for Indian companies here is that it will extend to all business partners of such in scope EU or non EU entities. So, anyone today who's making a supply of products to these large EU companies will definitely fall under this. So, you will have to ensure that there are no human rights violations. The environmental impact of your product you will have to ensure. A study by CDP and BCG says that any company will take 1 to 3 years to fully disclose supply chain emissions. So the preparedness has to start today, either in the form of, let's say, product certifications, which can tell you that there is ethical sourcing of raw materials, or in the form of IOSCO certifications, that where all our clients who are making exports to the EU, we're seeing that they're already equipped with this, or they're in final stages of kind of ensuring that they are compliant with these supply chain due diligence directives. Another one is the EUDR, which is also already in force, which is the EU deforestation regulations. Again, applicable to certain products, for instance, cattle, cocoa, soya, coffee, palm oil. But what it says is that you cannot produce any of your products which use these raw materials, or you cannot use these materials in the EU if this comes from a land which was deforested after December 2021. And if you do, then there is a large penalty of about 4% on terms of your global turnover. So again, lots for Indian companies to assess over here as well, that the land that where these products are growing, is it agri land, or is it a land which has been deforested? If it's a land which has been deforested, then what is the way out? Do you get a product certification for the ethical sourcing of raw materials which you're doing in India itself, so that really you can export it to the EU? Soya is also one important material which is included in EUDR, and India has huge soya exports to the EU. So these are a couple of EU regulations that I wanted to talk about, which have a direct impact on Indian businesses.
Very interesting. I think that just adds a lot of flavor to the general overview. And maybe what we'll do is now delve into some very specific, let's say, environment related questions, the E in ESG. And maybe Prasanjit, we start with you. There's just so much on the environmental side. There's climate change, there's environmental liabilities, there's risks from extreme weather, there's waste management practices, resource consumption. God only knows. How does a client circumference all of this into their diligence strategy? What's the way forward?
Yeah, no, Samir, that's a very important question. I think for the simple reason that we have seen, let's take real life cases without taking names. I mean, we know of a large Indian business house who had to shut their plant, which was basically facing a lot of backlash because of polluting rivers and impacting life around that. So no matter how big you are, if you are carrying on your business uh, adversely impacting environment, I think you are could be in for a root shock. So therefore, as an investor, you have to be very careful when you assess a target. Where is it located? Where the target has its plans? Is it really endangering, let's say, local animals, for example? Now, another Supreme Court judgment recently pronounced earlier this year, where basically the grid lines, power grid lines, were endangering a species of great Indian bustard, and the Supreme Court said no, you can't really carry on the having the transmission lines overhang, and you have to put it under the ground. Again, a lot if during diligence, if you suspect and spot that this kind of issues can come up, you must factor them in, because relocating your transmission lines or manufacturing plant will not only cause business interruption but a lot of cost also. So you must factor them in your valuation, in your deal document and structuring. So these are two cases where we saw, and there are numerous cases where India's National Green Tribunal has actually clamped down on businesses who are operating without full-fledged licenses. Some companies say, look, we have applied for a consent to operate and we are deeming an approval. I'm afraid that kind of argument will no longer hold good, and you better get a very, very clear approval with a clear expiry date, and work within the terms and conditions of those approvals. So, I mean, you when you diligence, you have to, of course, read the license approvals, whether it has expired, lapsed, but also look at the overall structure of the company's business from an environmental standpoint. Recently, we saw a hydropower dam which was being built collapse, and that caused destruction. So again, if a company is kind of building some projects, some plants, how well kosher is it? Is it in an economically fragile zone? If so, is it a red flag? So again, I think it sometimes superficially things may look good, but as they say, don't judge a book by its cover. Go inside what is mentioned and what is spelled out, in the policies of the company, how it operates, and that's very important when you do an environmental diligence. And I think again, if you suspect an issue, you must protect yourself by ensuring that if let's say you can't get a company to shift a plant overnight, that's very difficult. So you must protect yourself by having a value adjustment, price adjustment, a reduction in purchase price, some mechanism to tip the scales in your favor as a buyer. So I would say this holistic approach towards diligence rather than just a paper tick in the box diligence coupled with value protection is how I would say one should approach climate related risks. Again, another example I remember in one deal, there was a plant situated near a flood prone area. Obviously, floods were common during monsoons, and that was a factor which our client did negotiate, and we had kind of reduced the valuation factoring that in. And floods were common, and that can't be a force majeure excuse. So therefore, we kind of factored the flood aspect, and we factored it in our diligence as well as history, and as well as when we drafted the definitive agreements. So these are the kind of things you must look out for when you do the diligence and protect yourself.
Very interesting. And with this, I want to pick up something that one of our registering participants sent across as a question. And this was on greenwashing and disclosures. And Pavi, you briefly spoke about how there are increasingly significant disclosure obligations, let alone in Europe, but even in India. So, again, from a due diligence perspective, how do we address this? And how should greenwashing be addressed, especially considering how climate change and climate related cases are being addressed on a global level?
Sure. I think very topical question, very topical aspect that we're also increasingly seeing every day. Just to give you a back of the end calculation, there were about 230 new environmental climate litigation cases launched last year in the world, of which 70% were with respect to greenwashing and climate change. The way the climate change and greenwashing cases are typically divided is these can be three factors or three divisions. One is, of course, your corporate commitment, the second is your product specifications, and the third is in terms of what are your climate change policies. India today does not have a only specific greenwashing regulation. What we have recently launched is the ASCI, which is the Advertising Standard Council of India, which is it's a self-regulatory body with significant teeth. What it launched last year is certain guidelines for advertisers on greenwashing, and they were issued in Jan 2024. They essentially aim to address the issue of greenwashing, and it says that any advertiser which is making a comparative claim, for instance a product is friendlier, a product is greener, a product is circular, more sustainable, this has to be backed by a assurance, or it has to be backed by a service, superior service, to kind of clarify or to kind of verify that this product is actually the product which it is asserting to be. For instance, about carbon offsets, it says that if you are making a disclosure about a carbon offset, but that actual carbon offset has not happened in the next 2 years, then you will have to, as an advertiser, come forward and prominently disclose that, hey, 2 years have really elapsed, but really this carbon offset, we were not able to achieve this. So the ASCI has told you to kind of refrain from making these aspirational claims about future environmental objectives. The second most important regulation in India, which is still at the draft stage, but we definitely expect it to be approved soon, is the draft CCPA greenwashing guidelines. This is in respect of the Consumer Protection Act. Again, here the key obligations are that if you are making a claim in terms of your product being green, being sustainable, then please do not engage in greenwashing. Please do not pass on deceptive claims. And if your product says that it's clean, it's green, it's eco-friendly, then please get it verified from a third party verifier, right? And the third party verifier should provide adequate disclosures so that the claim that a product is green is adequately built in. There are, of course, the SEBI's to do's on greenwashing, against greenwashing for the green bonds as well, but that's really for a limited set. As Prasenjit very rightly spoke about the green versus green case, which is the Great Indian Bustard case. Which green do you actually protect? The Supreme Court held that the more important green must be protected. So it's really a landmark case where they've held that it's a fundamental right, and right against climate change is actually a fundamental right. Um, about 70% of the 230 greenwashing litigations and climate change litigations were actually 70% of them were decided in favor of the plaintiffs and the claimants. So that's a huge number for us to assess that this is definitely going somewhere. What we also advise a lot of our clients to do is that, when you are making these disclosures about your products being green, or even about your ESG tenets, getting a reasonable assurance or a third party assurance will automatically help you combat these greenwashing risks tomorrow. So that's one aspect that we regularly tell them. You can also ensure that there are certain checks and balances built, or certain, even in terms of remuneration for your employees. The more green objectives that your company achieves, your remuneration at the top pay level should kind of symbolize with the ESG scores that a company is achieving. So it's not just green and eco-friendly on paper, but also your remuneration somewhere matches. Several companies like BP, Shell, Pepsi, Coke, globally, they've really done this. And one must assess the carbon emissions they are making at each stage of the activity that a company is involved in. A slightly related topic here, but we were advising an IT company. Now, IT is one of those sectors where one thinks will have the least amount of carbon emissions if one has to talk about it, right? But the interesting point here is that when you are doing the diligence of an IT company, again, you must find this visible aspect to avoid a greenwashing, in the sense that an IT company may be making to you when you are in the process of acquiring them, investing in them. Just to give you some calculations here, about 6% of the companies in Iowa, 6% of water consumption in Iowa has really gone up because of the number of IT companies that it has. Google's water consumption has increased by 33%, again, because of the number of AI servers they have today. So, to give you a background here, the more AI servers you have, the more water you will need to heat and cool those AI servers. So we really are not never mindful that, your carbon emissions, your water usage can really go up just because you are an IT company. Let's think about a website. How can you make a website greener? If you reduce one page from the website landing page, it will reduce lot many carbon emissions. Can you make your website AAA compliant? Can you make your website more greener? Can it have a white background to make it astigmatism friendly, to make it friendly for those who are colorblind? Now, these are several aspects that one needs to be mindful of when you are diligencing an IT company, where they can definitely say that IT has the least amount of carbon emissions. But if you look at the world figures, about 3% of carbon emissions do come from the IT sector. I just wanted to give an example of one sector in terms of how to assess these DD aspects also, because this also contributes somewhere towards the greenwashing. And we definitely expect the government to launch stricter greenwashing regulations. Until then, these are certain aspects that one must definitely be mindful of.
Very interesting. One typically doesn't look at the IT sector as contributing to all of our pain collective. And Prasanjit, in your experience, let me start with human resources, so labor practices, and that becomes a very, very strong focus area from the social side of ESG, and whether it's policies on child labor, forced labor, how do you address those? What is the level of regulatory oversight that you expect the company to maintain over its ecosystem and its value system? How do you address this in due diligence, and how do you ascertain the risks?
Right, Samir. So I think the first thing is this is a very critical part of ESG, because more often than not, it's the workforce which is the really the heart and soul of a company. And if a company which is not taking care of its employees or is turning a blind eye to its employees, its well-being, then there's a big red flag, which I think many of my clients, international clients, do take note of that very seriously, and a lot of negative marks are given for that. Now, when I talk about the employees, it's not just a company's employees, but as a company, let's say if you have suppliers who are basically exploiting workers or having, let's say, child labor, as you mentioned, that is completely unacceptable. And we have seen in the past, again, not taking names, where very prominent companies have dropped very big suppliers from their playbook because they have not adhered to proper well-being of the employees who are being employed. So it's very critical that when we diligence these companies, we look at the entire ecosystem of the target company, its suppliers, anybody who is contributing to the pie and the business. How are they treating the employees? So, for example, some sectors are more vulnerable, like textile or agriculture. Are there child labor who are being deployed? What is the kind of social security they have been given? Are the children of the people working, they've been taken care of through a CSR initiative? Because ultimately, if you're educating their children, you're empowering them in the future. So I think all these steps, goes just above and beyond. Or is there a company just ticking the box of doing the bare minimum possible? Is there a history of kind of worker unrest? Has there been strikes, consistently strikes, which have happened? If so, that augurs very poorly as to what lies ahead, because that means the workers are not happy, and one should then look deeper into the situation. So it's very critical, and also, as I would say, target company, you must do periodical audits. You must get basically routine checks on your suppliers, educate them that what they should do as far as employees are concerned. Don't think if it's a contract worker, I don't care. That kind of approach will not take you anywhere. You must really ensure that every worker, whether he or she is called a consultant or whatever, doesn't mean that you treat them poorly and shabbily, because in the diligence scorecard, when as an investor I'm looking at, we will look at every employee, whether it's dressed up as a consultant or an employee, with same lens and glass, and see how are they being treated. Because that's really the heart and soul and spirit of ESG regulations and social regulations. The upliftment of the downtrodden, the employees who are contributing, the work engine, are they being really treated well? Another thing which I have seen many clients give a lot of value is constant upskilling. Are you really empowering your employee and workforce to keep a pace with the change times, which we are seeing today with the advent of AI? Or are you really letting them rot where they are? Very important that, these kind of additional steps of upskilling of employees is also done. Again, education, upskilling, making sure that if a worker is working in a hazardous industries, proper equipments are given. I have seen in many cases when on the ground diligence is concerned, we see appalling lack of infrastructure and basic safety equipment which are available for these workers. Now, again, without taking names, there was a massive fire in our neighborhood country. 1,000 people lost their lives, employees lost their lives. So if you see wires are dangling, it's a dangerous atmosphere to work, and you still send workers to work there. It's obviously not wise. In India, of course, we had the infamous Bhopal gas tragedy case, where chemicals were being leaked, and eventually so many people lost lives, not only workers and employees, but the entire innocent citizens. So it's very important that the company whom you're investing in not only kind of complies with the basic labor laws, but goes over and above to give a safe kind of a infrastructure for the employees to work. They should do periodic third party audits so that they get good certification about the safety nets being present. And I think all this should be factored in. Again, coming back to transactional documents, if you suspect any laxation on these fronts, please embolden and bolster your representation and warranties in the definitive agreements on the social front and the employee front, making sure that if the dues are not paid, any past dues are pending, any civil unrest is there, all this should be factored in, because this can lead to business disruption, mind you. So, and impact your business and whatever profits you may have factored in as a DCF method, for example, it can easily impact you. So factor all of this in the agreement, and I think that would be a good starting point.
I think very, very well summarized, Prasanjit. And Pavi, quickly coming back to you. Uh, from supply chain due diligence, there is a term we hear used a lot: scope 3 disclosures and scope 3 due diligence. How does that need to be factored in, and is it a mandatory requirement for Indian companies?
Sure, I think very, very important question. Uh, each company today is grappling with this issue. Let me start with the Indian regulations first. Like we had briefly discussed about the BRSR core in the beginning, the BRSR core introduces certain disclosure obligations on the value chains of these listed entities. Why its teeth is stronger here is because the value chain entities are defined to be 75% of your upstream or downstream entities. So any top 250 listed entity by market capitalization, any of its top 75% value chain partners, it could be your consumers, your suppliers, your producers, any of those in your value chain ecosystem, those nine ESG disclosures you will have to take from them. One good way to kind of ensure that you are meeting this is to have a good supplier code of conduct built into your contract with the supplier. There should be a regular update by your supplier there, so that you know that they are complying with XYZ norms, and that at the end of the year, when you are making this BRSR code disclosure to the SEBI, your annual report is not faltering. To discuss here also, the SEBI recently released a consultation paper in May, which kind of reduces the scope of the value chain disclosures specifically to mean the entities which will be engulfed in the scope of value chain partners. Now, if that amendment comes through, it will really solve a problem of a lot of listed entities, because it will shrink the scope of your value chain partners. And disclosures that value chain partners have to make are job creation in smaller towns, GHG emissions, their carbon footprint, their water usage, their intensity ratios. So, a lot of critical information has to be taken from a value chain partner. Now, as we move towards the EU, there is the EU CSDDD that we discussed about, where the non-EU entities which are in scope and also the EU entities have to ensure that environmental and human rights due diligence is being inbuilt in their directives, is being inbuilt in the directives of all the EU nations. And therefore, you're kind of identifying, eliminating, and mitigating these risks. Certain other countries in the EU already had these supply chain directives. To give you an example, the German Supply Chain Diligence Act already existed. France also has something very similar. And the first set of notices under the German Supply Chain Diligence Act have already been issued to companies like Tom Sawyer, Amazon, and IKEA, on the grounds that the premises where the textile manufacturing units were based in Bangladesh kind of violated the forced labor and the human rights protection norms. So we see that these notices have already been issued, and really upskilling, really ensuring that you're meeting these norms and requirements is a thing of the past. It's not a thing of the present or the future. Really, it had to be kind of initiated as of yesterday. Interestingly, very recently, the EU has also forced out certain other rules to say it's not yet implemented. But what it says is that if your product is manufactured through forced labor, the EU will stamp out those products from their market. They will either ban or they will donate it for free. Interestingly, if you would have heard, there is this province in China which is called as the Xinjiang region. About 90% of China's cotton comes from that region, and 20% of the world's cotton supply comes from that region. There is documented evidence that there is a forced labor aspect on minority ethnic groups in that region. So one will also have to be mindful if your big fashion brands are actually procuring cotton from some of these regions where forced labor is prominent. Of course, today it will be an expensive affair, but if a US customs authority stops you tomorrow, it will be a mega expensive affair, and then they will stop you every day, each day on a regular basis, and your business model is going to become absolutely inefficient, and it will be very expensive for you to then kind of keep paying those penalties. So these are, I think, some of the important aspects then one needs to be mindful of when I am thinking of my scope 3 or my supply chain. Scope 3 is really your value chain. A lot of we met with a couple of exporters who are in the refractories business, who are in the cement exports business, and they said when their EU counterparts visit their premises in India, even an asbestos ceiling becomes an issue. Even the kind of washroom that you have for your laborers on the premise, that becomes an issue. So I think these are the things that you need to be mindful of if you have exports with the EU, because you are the biggest supplier in their scoring of value chain. I think I'd leave it there, but happy to take any questions if somebody has on value chain specifically.
There are quite a few, Pavi, and in fact, it's interesting how the chat box has been buzzing with lots and lots of questions around that. So I'll come back to that. Why don't we do this? I'm mindful of time. We still have to get to the Q&A. So Prasanjit, one last question to you, and just help us sum up more from a governance perspective. When you look at an organization, there's a corporate culture at play because you can't necessarily integrate ESG into a company's strategy by prescription alone. There has to be some sort of an internal impetus. How do you evaluate something as soft and undefined during due diligence?
Uh, well, I think again, firstly, ESG cannot be an afterthought. It has to be, entrenched and integrated in the core fabric of the management of the company. So when we, from an investor standpoint, look at a company, we see, first the words. Of course, actions being louder than words, but first the words has to be there. And I think we have to see what kind of policies the company has. Does the top management actually is taking effort to really kind of complying with ESG in spirit and letter both. For example, the first question I think you asked me, Samir, was lack of uniform standard. Is the management hiding behind that and saying, look, I don't have to comply with GRI and whatnot? Or is the management taking proactive steps to talk to its suppliers, talk to its customers, talk to its financiers, talk to its investors, see what is their benchmark? They are doing a peer benchmarking, and then coming up with a holistic ESG policy, and then walking the talk, which means really having the policy but making sure there are periodic educative programs being done, periodic surveys being done, making sure that the employees are aware what should be done, what should not be done, whether it's whistleblower policy, why anti-corruption policy, and several other policies which are there and gathering dust, but employees and relevant stakeholders need to be educated periodically, time and again. uh, then next, what is the budget? See, you can have great ideas, but without proper budget allocation, a great idea will lose its essence. So is the company budgeting, allocating proper money to implement these initiatives on the ESG front? And has the money been spent? A quick look at the balance sheet will divulge that very quickly. Similarly, if the company is spending a lot of money on, let's say, environment remediational issues, that means there is something wrong, for example, with the environmental policies. So it's very important that the management's conduct is manifested both through the policies and well-formed policies, well-rounded policies, which takes into account a lot of the global thing, the relevant stakeholders input, and walking the talk, which means actual implementation by empowering and deployment of funds and implementation. So these are very critical aspects which we look at while doing assessment of a target company, both the letter and spirit. So it's not afterthought. The moment there's a deal baking, all of a sudden there's a lot of eye washing going on or greenwashing, and really people have not done historically much about ESG, and now they're waking up. That should not happen, and therefore I strongly advocate that any company and general counsels watching this should take appropriate steps to be ready, kind of ESG ready, so to speak.
Understood. No, I think that's very useful. And why don't we do this? There's been, I think we have less time left for the Q&A, but we'll still try and take some of the most interesting questions that have come up. But I must say it's been a terrific discussion. Thank you, Prasanjit and Pavi. But very quickly moving to the questions, and there's a very interesting one broadly in the context of the IT sector, and I'll start with that, Pavi, perhaps to you. You mentioned that the IT sector uh, does have exposure. Are there any uh, guidelines available that the IT sector should turn to generally, more in terms of good practices that they can look towards?
Right. So there are yes and no. There are no prescribed guidelines for the IT sector uh, to ensure that ESG metrics are met. All based on experience, really, is to ensure the emissions need to be factored in very well. We've recently been seeing companies like Meta, Google, etc., purchasing carbon credit certificates for the emissions they've actually been undertaking and the emissions that are actually happening because of their business. So I think carbon credits is an important aspect that an IT company must definitely think of. Also, because these are globally tradable on the voluntary carbon market. So, one very important thing that even from a business revenue model perspective, one can think of, but in terms of to-dos, really keep having your emissions monitored. Definitely have your value chains audited to the extent you can, and couple of aspects we discussed in terms of how can you make your website more ensure that there are less carbon emissions. Be mindful of how many people you are CCing and BCCing on an email, because that's also eventually increasing the carbon emissions. So those are certain important things that an IT company can definitely think of. And even when you are thinking of acquiring an IT company tomorrow, really carbon emissions, water usage, very, very important.
Perfect. And Prasanjit, now over to you. You mentioned about employees, and if people are not looking after their employees, that's a red flag. So there's a question that if a target has a track record of making employees work beyond office hours on a regular basis, is that something that impacts an M&A transaction?
Well, I think obviously, and I can see the the question and the timing of it also.
Yes.
But
Yes.
if an employee is being made overtime consistently and without an let's say, payment of overtime wages, that's obviously a red flag. That's point number one. Point
Correct.
number two is, even if somebody is being paid overtime, is it really kind of affecting the well-being of that person? That is also something which should be looked at. And is it an endemic kind of issue which runs raw deep in the system? And let's say a company is, working 18 hours to manufacture, let's say, X number of mobile handsets more. Yes, it adds to the profitability, but question to be asked is, does it not deplete the moral, of those employees? I think so. Yes, definitely, that's a factor, and that's the whole essence of ESG. It's just not the bottom line, but it's actually how you get to the bottom line. So again, I will not say even if you work for one more hour than what is stipulated, it's an offense. Of course not, because you are being paid overtime, and there could be necessities where you are working in any sector, whether manufacturing or service, to meet your deadlines. That's absolutely fine. But when it becomes a problem is when this becomes a recurring thing, and more than an exception, it becomes the norm. That is when I think it becomes a problem, and one should definitely address that. And it becomes a red flag in the report. Yes, that's the answer.
And now, Pavi, back to you. You mentioned the value chain enterprises, and if, when a company has to approve some criteria for value chain enterprises, is there any sort of a materiality threshold or any other sort of distinction or carve outs that they can draw up, or is it across the board?
Right. So, from a regulatory perspective, the materiality is anyone for a listed company which is falling in their 75% of their value chain perimeter. So, essentially, in your value chain, which entity is falling in the 75% of your value chain. You decide, you have the flexibility at least to decide that, but that should really be your materiality from what is regulatory prescription as of today. Like I mentioned, there is a lot of debate. The 75% should be reduced, and the consultation paper from the SEBI also addresses this issue. They've reduced the 75% so to a mere 2%. Uh, Hopefully, there will be a meeting of minds, and therefore, this materiality would definitely tend to increase if there is a change in law. So, that's one materiality aspect I can think of really in terms of what should be my materiality for value chain partners.
Understood. And maybe, Pavi, I stick with you. And you mentioned change in law, particularly for companies that are operating internationally. There will be increasingly more and more stringent local requirements. So, how do companies keep track of that, particularly with ESG, which is an up and coming area?
Right. I think upskilling is definitely in terms of your corporate governance aspect also, stakeholder engagement, engagement with customers, engagement with advisors. That kind of upskilling is incomparable in terms of value. And also looking at, for instance, we did a comparison of the BRSR reports of several top listed companies recently, and we saw how they are dealing with ESG matters. What kind of committees are they forming to deal with ESG matters? So, a lot of reference to context for smaller companies who want to be ESG compliant can also flow from the BRSR. For today in India, it's not a mandatory requirement to have an ESG committee, even for listed entities. But most listed entities either have a ESG compliance under the risk management committee, under the EHS committee, under the audit committee, and certain companies, for instance, HUL, Reliance, Infosys, they have a separate ESG committee of their own. So, a lot of reference in terms of practice for smaller companies can also come from there, and to see how they are trying to increase the circular economy construct, how they are trying to kind of match themselves with the EU directives. That's also a good reference for context. And of course, we'll be very happy to guide our clients in terms of the absolutely dynamic and changing global regulations affecting their businesses.
I think on that note, and we've given a lot of information to all of the audience who've attended. My apologies. We scrunched the Q&A, and there's of course a lot of questions we've not been able to address, but we will come back offline. Can I request Prasanjit if you can offer a few key takeaways to summarize and conclude the webinar?
Sure, Samir. I think again a lot of points. So uh, we will send, as Samir mentioned, a summary of whatever we have discussed in more detail. But if I were to summarize 5 6 points, I think firstly uh, that ESG is important, and therefore while doing diligence, first thing is that yes, the laws are still evolving. How we tackle ESG in India is still evolving. BRSR and all these are very recent developments, and as you could make out today, this is something which is still a work in progress, and therefore that is something one should be trying to keep pace with. But that's not an alibi to not do your homework and really kind of not follow what's happening around the world, borrow those standards, go the extra mile to make sure you're ESG compliant. So that's the first point. The second is, that fact that there is no ESG standard methodology or metrics. That again, as I mentioned, should not come in the way of really not consulting, doing surveys, talking to stakeholders, assimilating what should be done, and then walking the talk. So I would say that's the second very important point, which companies should do, so that when the diligence happens, they are kind of looking good. I think the third is the global landscape disclosure. What's the kind of disclosure regime being followed worldwide, and taking a cue out of that and making sure we're incorporating the relevant bits into our ESG compliance. And as far as investor is concerned, when you do your diligence, borrow those constructs and appropriately tailor them in the requisition list. Uh, I think the other key factor is, the climate risk is very important. That given the entire focus on how extremely the climate is fluctuating, changing, one must look at the target companies' emission, carbon footprint. What are they doing in order to mitigate against carbon emissions? Are they located in a environmentally fragile place, etc., etc., which we have discussed? Connected to this point is greenwashing. It can, a lot of kind of eye washing does go on, and as Pavi had mentioned, that a lot of litigations around ESG has been around greenwashing. So one must be very careful that as a target company, you are actually implementing what you are preaching, and really not indulging in just kind of taking the box exercises. Uh, Lastly, I would say that the supply chain scope 3 emission, that is a very important aspect, because more often than not, when we talk about ESG compliance, we think if as a company I am compliant, that's good enough. But as we have discussed in this webinar, it's not only what you do, how you kind of get your power, how you kind of operate with less reliance on fossil fuels, but more reliance on renewables. And most importantly, what does your supplier do? What is the kind of ESG compliance your suppliers and others in the value chain have? That is very pivotal when it comes to scope 3 compliance. So in summary, I will only say that, look, one cannot state more the significance of ESG, both from a target company standpoint. A lot of GCs who are watching, it's really, if you are a listed company, obviously you are on the way. If you're not listed, even then you must comply and look to comply appropriately with a lot of these which we have discussed. It will help you in raising green financing, cheap financing, attracting good valuation. And as far as investors are concerned, when you do diligence, consult experts on ESG, and we are happy to guide you to customize checklists, carry out diligence, and really advise you well, and draft your definitive documents in a manner which will mitigate any risk associated with non-compliance of ESG. Over to you, sir.
Thank you, Prasanjit. Thanks a lot. Uh, with that, ladies and gentlemen, we'll draw the webinar to a close. But before we do so, we'll request each of you to respond to a poll. It should be on your screen any moment now. It should take no more than 30 seconds. Thank you to everybody who's participating in the poll. And once we conclude the webinar, we will also send you a separate feedback form. It shouldn't take more than a minute for all of you to complete. And with that, once again, many, many thanks to Prasanjit and Pavi for such an outstanding discussion and for bringing so much information on what is otherwise a fairly dry and a fairly raw subject, but to circumference it in such a beautiful manner in the context of due diligence just goes to show that this is something which hopefully is looked into before it starts troubling people. And most importantly, many, many thanks to all of our audience for participating and participating so actively, both through your registration process as well as through the Q&A today. And as Prasanjit mentioned, we will send you a copy of the summary notes after the webinar. If you are interested in in-house training or any other matters arising from this webinar, please do not hesitate to contact us. We are just a stone's throw away. Our contact information is on the slide in front of you. Thank you for your attendance today once again, and we look forward to seeing you again at future editions of the In-House Council Forum.
Thank you very much for watching this. Thank you.
Thank you so much.